I believe we're live. We all set, Dave?
I think so.
Okay.
Live.
Fingers crossed, right?
Yeah.
Okay. Good evening. It is 5:18 PM. I'm going to call the Wednesday, July 17th, 2024 meeting of the Bangor Board of Appeals to order. My name is Ed Gould. I am the board chair. Item number one on our agenda is introductions, and why don't we start to my left with you, Justin, if you'd just introduce yourself for the record, please.
I'm Justin Cartier.
I'm Ed Gould.
I'm Jordan LaBeouf.
Don McCann.
And Justin and Don are both our associate members who will be participating in the meeting today. Next on the agenda is item number 2, approval of the minutes from the May 21st, 2024 meeting, which is in your packet. I hope everybody has had the opportunity to review them. Does anyone want to make a motion regarding the minutes?
I move to approve the minutes.
There's a motion, is there a second?
Second.
Moved and seconded. Any comments, questions, proposed amendments to the minutes? Hearing none, all those in favor say aye.
Aye.
It is unanimous. The third item is public hearing. The applicant is Carol Cutting with a concern regarding parking and driveway violations at 64 Fifth Street and 68 Fifth Street. Is the applicant here?
Yes, sir.
Are you Carol Cutting? Before we get started, Ms. Cutting, I wanted to raise a procedural
I'm
issue.
Tourette, so ignore that.
I'm sorry?
I'm Tourette, so I'm not.
Oh, okay, no problem. So I need to raise a procedural issue that has to do with the number of board members that are here today.
She should probably come to the podium.
Okay,
If you
Ms.
could
Cutting.
speak with her.
Sure. Ms. Cutting, why don't you come on up to the podium? And just, if you would you state your name and your address?
Yeah. Hi, I'm Carol Cutting. I live at 14 Eaton Place in Bangor, and I've lived there 25 years.
Right, thank you. So the issue that we have here is we have 4 board members, which is a quorum, but we don't have a full complement of 5 board members. So what that means is in voting on your application, in order to grant it, we would have to have 4 members voting in favor of your application. And that means it would have to be unanimous. So what I would like to do is ask you if you have any objection to proceeding with 4 members, or if you would like to continue it to another date when we may be able to get 5 members present.
I guess I have a question, if I could.
Sure.
So you've got 4 members, 2 associate members. What do those mean?
When we don't have, or when full voting members are not present, associate members step in and sit, and they're empowered to have the, same rights, duties, obligations as full board members.
How many members do you usually have?
We have, the full board is 7, and we need 4 for a quorum.
So you have to have at least 4, and there's usually 7, so almost half are missing.
Well, I wouldn't say usually. We only need to have 4 for a quorum. So under the ordinance, we're authorized to go forward today.
But only 5 vote, even if you have 7.
Right.
Right, thank you, John.
But only 5 vote, even if you have 7?
Yes, yes. So in other words, if we had 5 people here, you could have one person voting against your application, but 4 in favor, and it would pass. But because we only have 4 here today, all 4 of us would have to vote in favor of your application for it to pass.
You know, I've struggled with this for so long. I just got off an island 25 miles up to sea, spending $350 to get here with a dying cat. You know, I'm just going to say, take my chances,
Okay,
simply because I can't do it again.
understood, you know, I just
I literally
want,
flew in a single-engine plane in the farthest island next stop, Portugal, to be
okay.
here.
I just wanted you to be aware of that issue and
Thank
give you that
you for
opportunity.
explaining it too.
Okay. So, since you are here and since you're at the podium,
Excuse me for a second.
sure.
Yes, sir.
The floor is yours. You can present your case.
So, I wrote out the, I have Tourette's, and movements, extra noises and stuff like that. I can get past it, so just bear with me.
We will.
I had wrote the appeal up, and everybody's had a chance to have that and et cetera, so I don't have to completely go over that again.
That's right. It's in our packet. We've reviewed it. and
Okay, so I don't need to review it or anything, or just highlight it?
This is your opportunity to make your presentation and point out whatever you think is important to us.
Yeah. My son was gonna zoom in. I don't know if he did or not. Okay, so this is my backyard for the first 21 years I lived there. Did we say? No trees, no fence, no nothing. And this is my backyard as of 2020. In 2010, I did put up a fence because of behind me, if you've seen the packet, there's a diagram, there's an apartment building that goes there. The street goes here and this way, and that's Fifth Street. There's an apartment building there, there's another apartment building there. And this apartment is 64, and this is 68, there's no 66. So I put up a fence in 2010 because I was finding syringes in my yard, and I had a young son at that time who was 10. So I put up a wooden fence because people were jumping over and throwing things. So basically, there was a fence in 2010, but this is basically from 2000, for the first 21 years I lived there. That's what my backyard looked like. And I only had like 20 feet of grassy area because it was a big driveway because there used to be a barn there. And this, when I went away for the summer in 2020, the apartment building at 64 plowed their backyard completely. It's a 50 by almost 100. Most plowed almost the thing to dirt and started parking there. I attempted to negotiate with the landlord, and I said, okay, we'll let it go through the winter because it's October and it's COVID. And then we'll negotiate in the spring. I tried to negotiate for like a year since then, and it never worked. This apartment building, which is 68 behind this set of cars, they had parked, it had been vacant for about 10, 15 years. In 2018, they bought it and put a porch on, which limited one of the spots, and there used to be 2 huge trees that would block it. They used to have 3 cars that would park that way in like that, at an angle, so it wasn't as obtrusive. But anyways, this is my picture, did you need to see? Okay. Put up a fence in 2010. Number 64 has been a disrupted property. That's the one, right, if you look at the map, right, abuts my backyard. Since before this current owner owns it, since, you know, they bought it in 2012. The police are there quite often. Last spring, I found, I have a service dog for my Tourette's. It's doctor prescribed and it's trained and and he helps me with PTSD. He's not here today because he knows when I'm stressed, he will pull me out of a situation because that's what he's trained to do. And so the cars parking there really disrupt my service dog and his training for continuing PTSD. He's a newer dog. He's only 2.5 because my other one passed away. It also, whenever a car pulls in, I used to be a child protective worker and I have really bad PTSD. I jump and I scream and I run and those kinds of things. So it's really extra disruptive for me to have somebody parking like that. So it used to be, it's a disruptive property as well. Number 68 is just they copied the parking thing. In 2020, I talked to the manager of the one closest to me. He says, well, we met at the other one. But for 21 years, they've been parking in their driveway, which is by the house. It's a double driveway, that one. So for 21 years, they parked all the tenants' cars in the driveway. And when I went away, they decided to do more convenient parking of having nobody have to back to back. So one of my points is more convenient parking for me to have this in my backyard when they did it for 21 years the other way. And additionally, part of my appeal was saying, I don't know if Jeff Wallace has figured out yet or not, but it's always been a 3-unit. I'm thinking they changed, one of the reasons they may have changed the parking is because it looks like from the mailboxes and the trash cans, they're putting a 4th unit in there. But I don't know if that's been, figured out yet or not. But I'm also appealing the 4th apartment. And I mean, this really affects, I literally have 20 feet of grass before that fence. It really affects my ability to enjoy my yard. My service dog is really, it's not working, besides the fact that I recently, last February, found a sponge. Sponges can kill bugs in my yard thrown over. I called the police on that one, because the dog swallows the sponge and anything sucks it up and the vet can't find it. So the dog can actually die from it. I don't know if they did that or not, but I don't know where it came from, but, raccoons don't usually carry sponges. It's also an eyesore and a property valuation. In reading the codes for URD1s, these were all URD1s zones, it says that part of it is to create recreation in lower density spaces as it is able to do. This is not a lower density, this is a low density area, except that it's really in fact impacts the ability to recreate. Also, this appeal, this is a URD1 section, so this appeal, allowing this to go on, my point of arguing against Mr. Wallace's decision is that I believe the implication of the codes say that you're supposed to be parking in your driveway. To reference this, one of them, I had references in my thing, and one of them says you're supposed to be 5 feet from your neighbor's side lot yard and 10 feet from your neighbor's rear yard. The discrepancy of that makes no sense unless you are assuming that somebody's parking in the driveway, so they're 5 feet parallel to the neighbor and 10 feet before they hit the headlights hit the neighbor's backyard. That's the assumption, my assumption in the code. There's several other assumptions, like, an area needs to be, a backyard should be grassy and green and stuff like that I put in the appeal. My point is that something like this can happen next to Stephen King, it can happen on Norway, it can happen in Saratoga Ave, it can happen in Little City, anywhere in Bangor. According to this interpretation of the codes, this is legit. And this appeal, if it's not overturned, sets a precedent that this is allowed in anybody's neighborhood when the neighbor doesn't like them or wants more convenient parking, to plow the area flat, plow it 50 by, it's 100 feet, they probably plow 50 by 80 feet flat, and park cars anywhere they want, 4 feet from the side, up to 4 cars, or in the back. That's just a really not good thing that most people would tolerate. I don't think, any other neighborhood, but my point is that they're all the same zoned areas. They all have the same zoning of requirements for parking and not having to use their driveway as mine does. So, this affects all of Bangor, and it's a much globaler thing. And my point is that the codes imply that you should be using your driveway and not parking in the entire backyard. And I guess what I'm asking for also is this: I wasn't able to obtain an attorney at this time because they were busy. Not only does it set a legal precedent, but I'm also asking for a written finding of fact and conclusion of law, so that it does, so it's clear that this is how we're saying in a URD1 area. I'm not getting the camera. Do I need the camera? I don't need the camera. Anyways, that this is how Bangor allows people to park anywhere. We're talking Saratoga Ave, we're talking, 3rd Street, any other URD1 single family only or mostly single family only zone can park like this. And if it's not approved, then significant property evaluation. I'm done.
Carol, Jack is on the YouTube thing, he might comment, I don't know, but you can't see him. Her son's on there somewhere.
Is he there?
Yeah, he's on YouTube streaming or something, I just tell him.
I don't see him. This is my son who also lives in the house. He's currently getting a PhD in Rochester, so he's zooming in and trying.
Okay, we'll give him the opportunity to speak.
Okay.
We take one person at a time.
Okay, thank you.
Do any board members have any questions?
Yeah, yeah. If you have any questions, because I don't know if I've kind of bounced around, assuming that I didn't want to read my actual appeal to you.
Yeah, you didn't have to read it.
We read it.
Go ahead, Justin.
No, I was saying we read it, so it's.
Yeah.
Yeah. Okay. I did have, excuse me, a couple of questions. First of all, it's a little unclear from looking at the photos, but I think it's a little more clear from looking at the map that you included in your
Yes,
packet.
you need the map.
Do both of these properties abut your property?
No, this property abuts my property, and that property abuts the other apartment.
Okay,
So it's my property here, which is actually another street, and then there's another woman here that comes up to here, and these cars actually pull into her road too, and then there are two other apartments.
so you border 64.
Yes, I do,
And then 68 borders 64, but not you.
yes.
Okay, I understand, thank you.
This is 68, this is 64 is parking. And actually, they usually have another car there and whatever. They
Okay.
usually have 4 cars there in each place.
So the other question I had for you is, what exactly are you asking this board to do? In other words, what remedy would you like us to order?
I guess I would say park in your driveway like you have for 21 years. That you don't plow your whole backyard and not use it as a parking lot. I mean, for 21 years, they parked 5 cars there. Now, if they're expanding their apartments, they may have more of a parking problem, that's a different code issue. I'm saying, you parked there for 21 years, why do we have to park there now? And that, I guess that backyard shouldn't be totally used as parking lot. Now, 68 may be a little bit different situation, because they're more tight in there, but they could also put up some kind of screening. Simply because they also plowed their backyard, and they built a deck, which took away a parking spot. They have a single driveway. These guys at 64 have a double driveway. They used to park, I mean, I guess what I'm saying is, most of the neighborhood has to, I guess it's called back-to-back, one car behind the other. Most people have to do that in my neighborhood. You have to move when, your significant other would have to else get out. They did this because they used to do that before, and the 5th car would park in the street or pull in during snowstorms. But, I think they should be parking the way they did before and not using the entire backyard as a parking lot. And perhaps also clarify the codes that cars should be more parked in the driveway, like I feel the implication of the code actually is, given the fact that there's the huge discrepancy of 5 feet from the side yard and 10 feet from the rear yard. There's no other reason for that other than headlights. Headlights and coming and going. Because if these people set up car alarms, not only does my dog go nuts in training, but I also scream and have almost a cardiac episode. It's just really invasive. And that's not, I mean, if that was a driveway there and they were pulling in 5 feet from there, that would be different, because I probably would have bought the property 25 years ago, but also because they'd be in a different position. I mean, for parking in driveways, you have to have so many feet in front, so many feet behind, etc. So I guess what I'm asking is saying, park like you have for 21 years, and for these guys behind you, put up some kind of screening,
Do board members have any questions and follow-up? Okay. Thank you, Ms. Cuddy.
Thank you.
I will take any comments from online in a moment. Is there anybody else present who would like to speak in favor of the applicant? Okay, so Dave, if you could get Mr. Cutting online for us? Mr. Cutting, can you hear us?
Yes, can you hear me?
Yes, if you could, can you turn your camera on?
I don't see an option to. I see I see options to like change my microphone.
That's okay. It's not necessary. Could you just state your name and your residence, please?
Yes. So my name is Joseph, or Jack Cutting. You can call me Jack. And I live at 14 Eaton Place. Right now, I'm living in Rochester, New York, but this is just a temporary address for my school.
Okay. And you would like to speak in favor of the application, so go right ahead.
Yeah. So this change happens while I was away at Tufts University, and since then I've been able to come back and forth. And I spent summers and winter breaks at 14 Eaton Place. I will say it is a drastic change between what it used to be. Like it was just a normal, run-of-the-mill flat, backyard. Now it's repeatedly broken up by, like, if we do spend our time in the backyard, we can see these neighbors going back and forth, which is not really necessarily any fault of their own. I mean, of course, they're just using their driveway the way that their landlord intended, but the way that my mom has explained it, the way that I understand it, it's not, it's disruptive, and it's justifiably disruptive that all of these cars are parked in our backyard. And so I know when I was younger, my mom and I would spend a lot of time in the backyard and like utilize it the way that you would expect. I know that has not happened as much just because of my mom's PTSD. She's worried about disruptions and just different noises and like things coming from the usage of the backyard as a parking lot. And so I do support my mom's claim, or my mom's request, I guess, to see if there's anything we can do with either getting the residents of 68 to park in their driveway, to install some kind of barrier, or do something to alleviate this situation.
Okay. Do any of the board members have any questions for Mr. Cutting? All right, we don't have any other, we don't have any questions for you, Mr. Cutting. Thank you very much.
Thank you.
And one final ask, is there anyone else here who would like to speak in favor of the application? Is there anyone here who would like to speak in opposition to the application?
Well, I've been Carol's lifelong friend for like 40 years, and.
Ma'am, why don't you come on up to the.
Oh, sorry. Well,
That's okay.
yeah.
And if you could just tell us your name and where you live.
Patty Dunbar, I live in Herman, and I've been Carol's lifelong friend since we met in college, and I've spent time in her backyard as well, and it's awful that it's that disruptive to her. And having the Tourette's makes it that much worse. And I support her and Jack, and then, and hoping that some change can come about if possible. Thank you.
Okay, did anyone have any questions? Okay, thank you very much. So hearing no one in opposition, Dave or Jeff, do you want to present the city's position?
We will both do so.
Okay,
I think I will go first, and then first Jeff, and then perhaps come back later if anybody wants me to. So I'm David Sepchak, the city solicitor. I'm presenting the position of the city on this appeal. It's kind of a two-part thing. The first part is that it's been kind of difficult to really ascertain what the appeal was about, but the first thing is that we feel that the appeal is not appropriately before you because there's no code enforcement officer's order to appeal. There have been a lot of complaints that have been made in the past. The present one, you can see in your packet, there's an email from Ms. Cutting to Jeff Wallace, the code enforcement officer, making some allegations about 64 and 68 4th Street. Is it 4th Street? 5th Street, excuse me. 64 4th Street is adjacent to her property. 68 is not. It's the next one over after 64. But her email makes the arguments that his past decisions were ongoing, which the city would disagree with that. If there's a violation going on, there could be a violation going on today that wasn't going on 2 days ago. So she says that those decisions are ongoing and wanted an email or a written response to create an order to appeal from. And the response was provided by the city solicitor in the responding email. And basically the email says there's no order to appeal from. And so there are a couple of cases in Maine that I'm gonna suggest are authorities that would make it so that this decision should be dismissed because there's no appropriate order to appeal from. But there's gonna be a part two. So there's a case, Moore versus Town of Bar Harbor. It's a Supreme Judicial Court of Maine, 2009 case. And what it stands for is that the code enforcement officer in the Town of Bar Harbor was not required to investigate Moore's allegations. And so the code enforcement officer therefore did not misinterpret the town's land use ordinance. Because the code enforcement officer's determination to undertake an investigation is discretionary, it is not an appealable decision. That's 2009 ME Unpub Lexus 3 would be the site. And then there's another case, a Superior Court case, Terrence O'Connell versus Bar Harbor Board of Appeals. And that one is AP 2009-15. In that case, the Superior Court in Bar Harbor cited a Supreme Court case, Salisbury versus the Town of Bar Harbor from 2002, where the law court made it clear that the court is precluded from intruding into municipal decision-making when a municipality decides whether or not to undertake an enforcement action. And it also cites Moore versus the Town of Bar Harbor. And the court in that case was satisfied that the actions of the CEO in deciding not to undertake an enforcement action in the form of prosecuting a notice of violation falls within the sound discretion of the code enforcement officer, and nothing provided in the record compelled a different conclusion. So what I'm arguing first is that there's no order to appeal here. And so the appeal should be dismissed for that reason. However, I'm glad that Ms. Cuttings was allowed to go ahead and give her appeal, because the authorities on that are not clear. It's a little murky when we're talking about whether an order is appealable or not. So my second part of my presentation will be that to the extent that there is an order to appeal here, the appellant, Ms. Cutting, hasn't shown that there's been any kind of incorrect decision by the code enforcement officer. Today, it appears that, Ms. Cutting cites a number of ordinance provisions in her written appeal, and neither of the two neighbors are in violation of either one of those ordinances. The one that she made, she cited section 165-73, which sets up side lot line and rear lot line minimum distances. And the side lot line minimum distance is 5 feet for someone in this district, which is URD1. And the rear lot line is 10 feet. When the code enforcement officer comes up and presents, he's going to show you that based on whenever he's been there, there hasn't been any parking within 5 feet of the side lot line. And in fact, there are trees in the way so that the cars would be farther than 5 feet out from the side lot line. So there's no violation there. Another ordinance, and there's also no rear lot line violation either. One of the arguments that I heard Ms. Cutting make was that they're parking in their yard as opposed to in the driveway, but there is no ordinance that requires parking in the yard, in the driveway. There's no violation there, and I can let Mr. Wallace talk a little more about that. Another ordinance that Ms. Cutting cited was 71-24. That ordinance doesn't apply. It only applies in the Bangor Center revitalization area. And there's a page in your packet right after that particular ordinance provision that shows where the Bangor revitalization area is, and her property is not close to that, so that ordinance just doesn't apply. There are another ordinance that she cited, 165-74, that talks about parking. That's not relevant. It only applies to large parking areas of 50 or more spaces, which this is not one of those. See if there's a second part of 165-74 here. Bear with me for one moment. Yeah, 50 or more spaces is what that applies to. She also, 165-73 is another ordinance that she cited in her. That one is the one that has the rear and the side lot lines, but it also it talks about that there has to be screening for parking lots containing 5 or more spaces, which doesn't apply here. You'll hear the code enforcement officer present that each time he has come out in the past, not in response to her most recent communication, but he's never found more than 4 vehicles parked at 64 or 68. And it also the 5 or more spaces, I believe that doesn't apply in URD1 zones.
Yeah, but I've never found more than 5, yeah, that's fine.
Yeah, okay. So, there aren't any ordinances that Ms. Cutting has cited that are being violated. So this is our substantive response and presentation in response to her appealing to the board. And I'm gonna let Jeff Wallace take over and talk about what he's done and found, but you're welcome if they have any questions.
Yeah, before you do any board members have any questions for Dave? Okay, thank you, Dave.
Okay, thanks.
Good evening, Jeff Wallace, Director of Code Enforcement. I think the easiest way probably to describe this is to give a little history with the property and what I've found and therefore why I've always found it to be in compliance. I have been in contact with Ms. Cutting, gosh, probably since 2020. It's, 3 or 4 years on this, looking into complaints. I've gone over, obviously if I just go over there, during my working hours, I'm likely to see, the same cars gone all the time. So I've gone over nights, weekends, different times of day, just to, get, a good vibe of what's going on over there. And every time I've found 4 or less. And why that is important is the screening requirements for a parking area in URD1. That's tripped at 5 cars. So if I were to go over there and see 5 cars consistently, I would reach out to the owner and say, you need to plant some trees, do some screening. But I have yet to see that. So I think that the first place to start here on the recent changes, as she said, you know, they kind of, you know, created some parking areas in the back lots. Our ordinance read that if you disturb more than 10,000 square feet or affect the grade more than 12 inches, then yes, you get a grade and fill permit. The grade out there is all the same, so there's been no topography changes there, so that checks out. And I measured 64 Fifth Street to be about 2,170 square feet, and the one at 68 to be 1,443 square feet, so both considerably under the 10,000 square foot threshold where they would have, you know, had to come to us for a grade and fill permit to create these parking areas. As Dave said, there are some references that Ms. Cutting gave in her appeal. I think he walked through them earlier, so there's not a whole lot to repeat there. But what I would like to do is show some pictures. 1, 2, 3, 4. And kind of walk you through these. These demonstrate. Sorry, we don't have a color printer in the code office. Yeah. And these were taken, as the date says on there, relatively recently, July 9th. The first picture here shows the driveway at 64 Fifth Street. As Carol said, they're not parking in that. My contention is that the code doesn't imply anything. It says parking may be done in driveways. It doesn't say it shall, it must, or it should. It gives an option. It may. The second picture shows a rather large tree within 5 feet of the sideline, which is, this tree is right at the edge of the parking lot. So obviously they're not parking within 5 feet. At that point, the next picture with the Nissan and the trees back show that it's greater than 10 feet to the rear of the property. So they're in compliance. They're not parking within 10 feet of the rear of the property. The next picture, which shows the 2 cars and the parking area, it shows, again, where they are parking. It shows that there were 2 present at the time. So thus in compliance. The next picture, which shows a little bit more than 7 feet, is the closest of the cars from the picture before, but that's showing, again, they're not within 5 feet of the property line. Then we've got to look down from a couple of the trees within 5 feet there, one really close in the frame and one further down, and some small trees, oaks or something, I don't know what they are, but those are all within 5 feet of the line, and as you can see, those are all intact. So if cars were parking within 5 feet, those small little sapling trees would be disturbed. They're not, so that demonstrates that they are in compliance with the setback regulations. The next one's, again, another little photo of a small little sapling tree that would be disturbed if it's within the 5 feet. Then we have another one that shows 5 feet, which again just determining that all those little trees are in that area. And then I think the last one of the group shows a car between 10 and 11 feet off the sideline. Again, just showing that they are in compliance. And that's a good sort of, that's like the average findings over there, you know, the cars are parked in that same general location, there's always less than 4 or less. So therefore, I have not found the property to be in violation, thus have not issued any notice of violation or corrective action. I think that's pretty much my take on it. If there are any questions?
Questions for Jeff?
Just one quick one, and thank you for this pictorial history, Jeff. It really shows you're doing your due diligence and researching all of this. It's evident that they're following everything. Were you able to find, one of her accusations was there was a 4th unit being there? Were you able to find anything in your investigation on that?
I did reach out to the owner, and there are 4 units there, and we are working with them to get that into compliance.
Excellent. That's all I have.
Any other questions?
With that 4th unit wouldn't change anything for the parking purposes.
Not that I can think of, because I mean, that 4th unit's been in there during this whole time period. And the numbers have been okay during that whole time.
Sorry, to clarify, the ordinance wouldn't change the interaction of the parking with the city ordinance. It wouldn't allow more parking spaces, it wouldn't reduce the number of available vehicles, it wouldn't add a setback change or anything.
No, the setback, all those would stay the same. Again, if the actual number of vehicles there, it would, could trip the screening requirements if there were more than 5.
Other questions?
Can I ask a couple quick questions to Mr. Wong?
Sure.
So, Jeff, is there any problem, well, first of all, there's a wooden fence on that side of the property, right?
Yes, one of the pictures, the one that showed sort of the whole parking area, does show the fence that runs the whole length between the 2 properties, yes.
And about how high is that wooden fence?
I would guess between 6 and 7.
6.
Feet?
There we go, 6. Yep.
All right, and is there any problem with the vehicles parking what I call horizontally on the property?
No, our ordinance doesn't give any direction as to perpendicular angle or parallel. It just mentions the number of spaces, not an orientation of the spaces.
Other questions for Jeff?
Can I ask one?
No, I'm sorry. We don't open it up for, cross-examination by public members.
Just a quick question, that's all it was.
Yeah, I'm sorry, our rules don't allow for that. Other questions from the board? Okay, thank you, Jeff.
Thank you.
And Dave, does that end the city's presentation?
Yes, it does.
Okay.
Available for any questions.
John, remind me, I forget, do we offer the applicant an opportunity for rebuttal?
I think you should.
Okay. Ms. Cutting, if you would like to address any of the issues that have been raised, you're welcome to.
I'm going to refer to the city attorney as Mr. Ag. That's because I don't want to butcher his name. Okay. The city solicitor said 2 things. The decision was that there's no thing to appeal. And he cited some court references. But he did not say that, my understanding is that the court can't force you to enforce codes. That you guys do. The appeal board is what forces people to enforce codes or interpret codes. So those quotes he made about Bar Harbor and the different places really aren't that relevant if we're talking about an appeal board. We're not talking about court. We're talking about the appeal board making a decision about a code interpretation. And then he said that there wasn't anything to appeal. Well, but then both gentlemen spoke about going out and assessing, and in fact, they did make a decision. They made a decision that it was within the code. That is a fact of decision. That is why we're here, because there was a decision not to do anything by saying it was within how Mr. Wallace interpreted the code. So therefore, it is a decision that I'm here appealing. It may have gone on for a long time because I asked the city manager, both of them before they came, how do I appeal this? I asked the city solicitor, how do I appeal this? Well, it's a code decision. Nobody ever said, I asked the city council, I've been to city council asking this. Apparently I went to the wrong people. Nobody ever said, well, you can appeal it to the codes, which I didn't know. I figured that they would make the decision. So here I am with an actual decision of not to do anything for a decision. At an appeal board that, is not a court of law. You guys are an appeal board, you're not a court of law. And I'm not a lawyer, I'm a social worker, and I don't know whether a court of law can overrule, I guess it can. First it has to go through the appeal board, I think. I'm arguing not that, we talk about pictures of how far away the cars are, 4 versus 5 cars. And at different times, they have been closer. That tree is in one place where they park. They have been closer, they have been further away. The average car is 13 feet. If it's 10 feet away, heaven forbid, that's 23 feet of the 50 foot they have to access it. So in the winter, it gets tighter. I'm not, and occasionally there is a 5th car there, but I'm not arguing those little details. I'm arguing that, that this is a decision. Is that the parallel versus horizontal, it's parallel, perpendicular versus parallel. The 5 foot parallel to the sideline. Sorry, I've been on an island for too long. The 5 feet parallel to the sideline, that is clearly there for a reason. That's what you guys need to interpret. The 10 foot near the rear line, why is the difference? 5 feet from this side, 10 feet from here. Because your neighbor's having a cookout here, right here is your parking lot, your driveway. They're not saying 10 feet from the sideline. Why is that? Because I'm saying, because the code implies that you're supposed to be parking in your driveway or something close to it. There was a picture of 64 Fifth that was in the handout that I was just passed on. They used to park, it's a double driveway. They used to park back to back, one car back to back, one car back to back, and the 5th would pull in during bad storms in the middle for 21 years. The 4th apartment, which is, it's not been there forever. It's only been there, I'm guessing, around 2022, because I had emailed Mr. Wallace in the back saying, there's another mailbox up, they're constructing it, looks like a 4th apartment's being shoved in. And the 4th apartment is significant because somebody asked, does it affect the parking, does it affect the number of cars? No, they can still have these 4 cars here. If they put a 5th one there, then they're in trouble. But, correct me if I'm wrong, Mr. Wallace, they can also, in that driveway, they can also park as many cars as they want, because it's a unit more than 2 units. So technically, they can park as many cars as they can fit space to pace in the driveway, as well as 4 back here. And that's why I think they changed the parking. Who changes parking after 21 years? When the neighbor tries to negotiate and says, I'll let it go this winter, but it's not okay. And again, we're saying, is this what we want for Bangor? How do we interpret it? The 5 versus the 10, I believe, is the interpretation of the code. And the whole thing is that there's no violation of parking that way. That is what I'm appealing. I'm saying, is this okay for URD1, single family, highest restricted zone in Bangor? Because that is what we're dealing with, my house and the apartments there. They're apartments in a single family, but they've been snuck over the years. The 4th apartment was snuck in, probably but not, it's been in violation for a while, but the unit building itself has not been full. And I suspect that will be parking in the driveway as well. Those cars do not need to be screened. It's a question, if those cars don't need to be screened, do the other 4 need to be screened? If there's a 5th one there, I'm not going to. And they said you can plow up to 10,000 square feet without a permit. Well, 10,000 square feet is 100 by 100. That means both of these driveways, if they're owned by one person, could plow it completely flat without a permit. Their whole driveway is only 50 by 100. That's a quarter of what's required. And there was no heads up to the code office, we're changing anything. And also, they have been parking further away. I noticed I've been away again on an island. They have been parking further away since I've been back, since I launched the appeal, because that's what people do. So, again, the references to the law stuff, I don't think it's relevant, because we're not talking a court of law. You guys are a board of appeals. you make different decisions on whether a code is interpreted correctly. And I'm appealing, not the code officer's decision, I'm appealing his decision based on the interpretation of the codes, which, is this what we want next to Stephen King's house, noise, doctors that live in the other, on Saratoga Ave? Because if you say that this is okay, then it's okay there for all of their neighbors. In fact, you're giving a legal precedent. Lower. And I would like a written finding of fact, conclusion of law. Any questions? That was my.
Any questions for Ms. Cutting? Okay,
Yeah.
thank you very much.
Thank you, sir.
All right, so I will now close the public portion of tonight's hearing and open it up to the board for discussion.
So in my understanding of our purview as the Board of Appeals, I understand that we have specific guidelines about what we can and can't do as a board. In this particular case, what we can't do, what is not described under our purview is an interpretation of ordinances or issue orders to the effect of how those ordinances ought to be interpreted. What we can do is look at a decision that has been issued and make a decision about whether that interpretation was done in error. I don't see in this case, a decision being issued by the code enforcement officer that is inconsistent with the code of the city that we could review. If we were reviewing a decision based on that code, I don't see a clear violation of the code as written. I don't think it's within our purview to decide what is implied by the code, but instead to make decisions based on what is written in the code. And so for that reason, I don't see a clear reason to support the appeal.
Other discussion?
Yeah, I definitely feel for Ms. Cutting's situation.
Sure.
It's a very tough situation to be in, especially when you get so used to, for almost 20 years, your use and enjoyment of your property being a certain way. I was hopeful that we would find something that was in violation. And even I think if this property reaches the 5-vehicle threshold, which would induce the need for some buffering, it does appear from the photos that Jeff Wallace has provided that by allowing those maple trees to grow up, that they are already starting to meet that requirement should they continue to let these trees grow up. There may be 1 or 2 places along there that they're not, but in my opinion, it'll be a year. I mean, there's already some of the trees are starting to reach over the fence, so I'm hopeful that the landlord will continue to foster the growth of those trees to help give her a buffer and hopefully ease the situation for everyone involved. It's definitely a tough situation here for probably both the tenants on Fifth Street as well as Ms. Cutting and her family. Mm-hmm. For sure.
Other comments or questions? Okay. The way I look at this is that I think what Ms. Cutting is really asking us to do is to order Jeff to enforce the land use ordinance. But as a Board of Appeals, our power and our jurisdiction is limited by the ordinance. And under a circumstance like this, we're authorized to look at a decision of the code enforcement officer and decide whether or not it comports with the applicable facts and the law. But we don't have any authority to affirmatively tell a city officer to go out and take some action. We do have some authority if somebody files an appeal and says, we think that that action is wrong, mistaken, improper, not in accordance with the law. I mean, we can consider that and act on that. But we can't affirmatively tell the code enforcement officer to go out and issue a some sort of notice of a violation. So I don't see that we have any authority to do what Ms. Cutting is asking us to do. Anybody else have any other comments or discussion?
Yeah, Ed, just to think about if there is a remedy, where the remedy might lie would be a change of the code, which we don't obviously have the power to do, but.
Right, and, whether or not Ms. Cutting may have some private right of action that she could bring against the other landowners, that she could pursue, through hiring her own attorney and see if she has any individual legal remedies. I'm not going to comment on that, but again, that's outside of our jurisdiction and not something that we can do. Okay, any other comments? Would anyone like to make a motion regarding the pending application?
I move that we deny the pending application.
Is there a second?
I second.
Moved and seconded. Any further discussion or comments? Hearing none, all those in favor say aye.
Aye.
And it is a unanimous vote. Sorry, Ms. Cutting.
I guess I have to sell.
The last item on the agenda is other business. Does anybody have any other business to bring before the board?
The only thing that I would like to say is that a week from today, we'll reconvene.
Yes.
I'll prepare some findings and conclusions based on what you've said tonight, and then you can tell me to fix it, throw it out, do whatever you want with it. But then you'll need to adopt a final decision.
Right.
Which then is appealable to Superior Court.
I do have one other matter to bring before the board. We have another public hearing on the schedule. I'm not sure of the date, and I'm not sure of the status of whether or not there's a quorum, but I've got at least what I consider to be a conflict regarding regarding the applicant in that case. So I'm going to recuse myself from that. That means we need to have an acting chair for the next meeting. So I'm going to submit it to the board. Number one, does anybody want to step into the shoes of the acting chair? And number two, should we have a vote on it now so that we'll be ready to go for the next meeting?
When you've done that, when you needed to do that before, Robin was kind enough to step into that role, and I'd like to nominate her in absence. But actually, I do think that it might be useful to do that in the meeting, depending on who is present at the time.
And if nobody that's sitting here is willing to do that, I'm not going to ask you to do it, and I'm also not going to ask Robin to do it in her absence.
Of course.
So unless anybody wants to, take a step forward and offer their services as the acting chair, we can just defer it to the next meeting.
Yeah.
Okay. Does anybody want to make a motion to adjourn?
So moved.
Second?
Second?
All those in favor?
Aye.
Meeting's adjourned. Thank you, everybody.
Thank you.
May I have one of those packets of photographs so I can keep it for the official?
You can have,
You can have all of them.
that's right.
right.